Hello, hello, hello. Beautiful creatures of the internet. I'm Mango Jones. I am running late today. I'm like 6 minutes behind. I know. But I have coffee and I was doing like adulting stuff and or themes. So there's that. Um as always in my description there are links to all of the members of the Stream Pervs family. You will also find a link to the Indigenous people charities that Security Monitor Lizard and I are fundraising for. We are not sponsored by any of these people. We do not work for them in any way, shape, or form. We are just trying to do a good. So you click the link, you make a donation, you take a screenshot of your receipt, you black out your personal information, and you send it to postalaguana@gmail.com. If we reach our goal of $2,000, we will be eating a Cobes burger. For every one-time $150 donation to one of those charities, we will be eating a Code Red hard-boiled Mountain Dew egg. Mountain Dew Code Red hard-boiled egg. There we go. Yeah. We reach a $2,500 goal, then Slim Cyborg and Dungeon Queen will be going egg for egg with us, and Slim, being the absolute sweetheart that he is, will be eating the Copes burger as well because his stomach can handle it. Queen's cannot. It's a whole thing. So yeah, that is my spiel. Whew. I'm sorry I'm late, guys. Yes. Hello, Todd Malicote. Yes, you are here for it even. I'm sorry that you'll be at work, Jojo. That sucks. Here, I am going to put this in the chat and I'm going to pin it because I'm smart or something, or I can't find what I'm looking for. There it is. There we go. Okay, now we're going to pin that. Yeah. All right, doing the streaming stuff. Woo. Okay, so today we're going to be talking about the state of Indiana versus Richard Allen. If y'all are unaware of who that is, back on February 13th, 2017, two teenage girls went missing in Delphi, Indiana. Their bodies were found on February 14th, the very next day. This has been an ongoing case. This is a 5-year-long case. We do have just this one single person that has ever been arrested and tried for anything in connection to the Delphi murders. Richard Allen. There have been a lot of moving parts to this piece, and we will talk about the other parts to this piece. However, comma space, the most important thing right now is Richard Allen. He is facing murder charges. He does have a hearing this week on the 13th. So we're going to look at his chronological case summary. We're going to go over the laws, and we're going to talk about just everything that has happened in terms of him. Next week, we will be covering Keegan Klein. He's a moving part to this. We're going to talk about Ronald Logan. He's a moving part to this, but Ronald Logan sadly passed away at the beginning of this. Nope, last year. Sorry, getting ahead of myself. But yeah, so let's look at stuff and things and or themes. Good morning, broccoli monster, rot, lizard. All right, so now, I want to make it just absolutely clear that everything that we are currently looking at is, in fact, public record. This is stuff that you can easily access on your own. We are on the Indiana case search site. You can search him by his name, or you can search him by his case number, which I will be doing case number, and I will be providing at the end of all of this. Where is my... Haha. At the end of all this, I will provide a lovely link to all of the stuff and themes that I'm going over. So here we are, the state of Indiana versus Richard Allen. This is a pending case. So on October 28th, we did get word that someone had been arrested in connection with the Delphi murders. They released his name. They did not release a mugshot at the time. We just knew that his name was Richard Allen. They did not say what he was being charged with. They just said, hey, on the 31st, we're going to be having a nice little press conference. We'll let you know all of the details then, right? So We didn't know any of it. None of this stuff had been updated on the chronological case summary. So, as you can see, the petition got filed on the 28th. The verified request to prohibit public access to a court record. You see, in the state of Indiana, in their rules of public court record access, they do have rules that state that you can file a request to have stuff blocked from the public pending public hearing. So once you file that request, anything that you file after that does not have to be public record within reason. The chronological case summary does have to be updated. They do have to let you know these are the charges, this is what's currently happening, but they do not have to put out any other information beyond that. So at the time, again, we knew that he was arrested. We didn't know what for. The chronological case summary actually did not get updated until November 2nd. So all of this stuff that's here, the information that's filed, the probable cause affidavit, the order that was issued, we didn't know any of it. We had no idea any of it. That information got released on the 2nd, but we'll get to that. So from what we know from the charges filed and the order that things went, the charge that was filed was murder. And at the time, we didn't have the information. The charging documents were not something that was public record. So when you look at that murder charge says a person, because it's Indiana Code 35-42-1-12, which is a person who kills another human being while committing or attempting to commit arson, burglary, child molesting, consumer product tampering, criminal deviant conduct under IC 3542-4-2 before its repeal, kidnapping, rape, robbery, human trafficking, promotion of a human labor trafficking, promotion of human sexual trafficking, promotion of child sexual trafficking, promotion of sexual trafficking of a younger child, child sexual trafficking, or carjacking before its repeal. So naturally, you see this murder charge, you see what all it could be associated with, and people went into a tizzy thinking that it was some CSAM related thing, especially due to Keegan Kline, but we will talk about Keegan Kline another day. Now, that is not the case. We know now from the charging documents that actually it is because of something completely different. I will pull that up for you. Because I have it. Hold on. I'm getting better at this, I swear. Not really. We'll just share the entire screen. Ready, set, go. Okay, so right here, we have our document. Ta-da! So, Richard Allen was charged with murder, and as you can see from the charging document, from the information, it is while committing or attempting to commit kidnapping. So yes, it falls under Indiana Code 3542-1-12, but not for any CSAM stuff. It's purely because of kidnapping. There's a lot of details of this case that have never been released to the public. Okay. In the Ron Logan search warrants and everything that we will go over another day, there's stuff that had to be left out because it could impede the investigation. There's stuff that the Murder Sheets podcast put out. Shout out to Murder Sheets. They're amazing. There's stuff that they put out that could not be released to the public because it would impede the investigation. So we don't know how Abby and Libby were murdered. We just know that they were. And that's the most important thing. They were. Okay? all that fucking matters. They were murdered. Now, we know that he was charged under kidnapping, murder while trying to kidnap, and that was for both Libby and Abby. See? Count 2, murder, same thing. Now, we know that. That's all well and good. We know that a probable cause affidavit did get filed. We do not have the unredacted version of this document. We will likely never see the unredacted version of this document. Coffee. But what we do know is that ta-da! So this entire thing was submitted pursuant to Indiana Code 35337-2, which is a probable cause, affidavit, or oral presentation under oath, record determination, detention, or release. That's the entire name of the chapter, okay? So, at a time at or before the initial hearing of a person arrested without a warrant for a crime, the facts upon which the arrest was made shall be submitted to the judicial officer ex parte in a probable cause affidavit. That is this. In lieu of the affidavit or in addition to it, the facts may be submitted orally under oath to the judicial officer. If facts upon which the arrest was made are submitted orally, the proceeding shall be recorded by a court reporter, and upon request of any party in the case or upon order of the court, the record of the proceeding shall be transcribed. If the judicial officer determines that there is probable cause to believe that any crime was committed and that the arrested person committed it, the judicial officer shall order that the arrested person be held to answer in the proper court, which falls directly in line with exactly what we see inside of this, because the probable cause affidavit was filed, the order was issued that there was probable cause found. He probably murdered them. And then there was the order for the initial hearing. Okay? Now, an initial hearing, again, in the state of Indiana, you don't have to be arrested with a warrant. Like, that goes for any state, but specifically speaking in Indiana, there is various codes for arrest and for everything that says that it just does not have to happen. Hi, Yato. I'm not going to yell at you. Not today. Not today. Hey, look, it is you. Cool. I'm going to make you a mod so I don't, forget you. Okay, so now, what really confused most people when it came to his arrest, to his initial hearing, to all of that, is that he actually was given a bail amount, and that's not supposed to happen for a murder charge in Indiana. Murder is not supposed to be a bailable offense. However, there are various rules behind that. Like, you have to be able to prove without a shadow of a doubt that there was fucking murder, It's a whole thing. So, let's look over this probable cause affidavit, because, this is the reason that he is getting these charges, okay? So, February 14th, 2017, Victim 1 and Victim 2 were found deceased in the woods approximately 0.2 miles northeast of the Monon High Bridge in Carroll County. Their bodies were located on the north side of Deer Creek. Okay. Now, one thing that we know, one thing that was released to the public, were that Victim 1 and Victim 2 had been hanging out at the bridge. I think they referred to Libby as Victim 1. No, Victim 2. Victim 2 is Libby. Her sister dropped them off to hang out because they had a snow day. Like, they were hanging out. They were having a good time, you know? And we do know that she got video and audio of the biggest suspect. They called him Bridge Guy in, like, everything that they put out. Bridge Guy. Bridge Guy was creepy as shit. Okay. Now, it says right here, the video recovered from Victim 2's phone shows Victim 1 walking southeast on the bridge while a male subject wearing a dark jacket and jeans walks behind her. As the male suspect approaches Victim 1 and 2, one of the victims mentions gun. Near the end of the video, a male is seen and heard telling the girls, guys, down the hill. The girls then begin to proceed down the hill and the video ends. A still photograph taken from the video and the guys down the hill audio was subsequently released to the public to assist investigators in identifying the male. Now, a lot of people thought that it was Ron Logan. And we will go over Ron Logan and all of his issues and stuff. But yeah, this does not point to Ron Logan. Okay. And we need to quit talking about like Ron Logan being the guy. Like there's a lot of stuff there. We'll go over it though. Okay, so Victim 1 and Victim 2's death were ruled as homicides. Clothes were found in Deer Creek belonging to Victim 1 and 2 south of where their body was located. There was also a .40 caliber unspent round less than 2 feet away from Victim 2's body between Victims 1 and 2. The round was unspent and had extraction marks on it. Interviews were conducted with 3 juveniles. They advised they were on the trail on February 13th. They said that they were walking on the trail towards Freedom Bridge to go home when they encountered a male walking from Freedom Bridge to the other bridge. Described him as kind of creepy. He was wearing blue jeans, a like really light blue jacket, and his hair was gray, maybe a little brown. He didn't really show his face. And they advised that it was a duck canvas type jacket. They said hi to him, but he just glared, and she recalled him being in all black and had something covering his mouth. She described him as not very tall with a bigger build, no bigger than 5'10". Okay. Like all of these details, super important. Like it's so great that they were able to report these things at the time of the incident. Okay. And actually what's great is this person who stated that he had his hands in his pocket showed investigators photos that she took on her phone while she was on the trail. And the photos include a photo of the Monon High Bridge taken at 12:43 p.m. This person had commented on stuff on Facebook after the incident had happened, and she felt so bad because she had been there. She had seen the person in the video. Only one news outlet ever picked up on her having been there and her having said things on Facebook. People on Reddit, they were just like, you know, the pictures and stuff that you're posting under these Facebook posts don't exactly say that you were there. However, comma space, like she actually talked to investigators that day. Like she actually spoke to them. So, compared to the Idaho documents, this seems really light on evidence. That is why this is a probable cause affidavit and not a definitive affidavit. You know what I mean? Like this is all probable cause. They had enough probable cause to arrest him and charge him with the murders. But like I said, there's a lot of moving pieces to this case. Yeah. The whole Keegan Kline thing, we'll get into that, but it's entirely possible that here within the next few weeks, maybe even the next few months, we are very likely going to see more people arrested having to do with this. Because there was a lot of stuff. But yes, this entire affidavit is the probable cause affidavit. So, yeah. But yes, so the people that they interviewed, all of them described him as being there, the way that he looked, the way that he was dressed, what he was wearing, that whole thing. Now, they did determine that there were other people on the trail after 2:13 p.m. and none of them had encountered the guy that was on the bridge, nor had they encountered the two girls. Like, no one had seen them. Like, they were just poof, gone. The FBI did say in their affidavit to be able to search Ron Logan's house that it looked like the bodies had been staged. So it is possible that they were taken somewhere and then brought back. But we don't know that for sure. We cannot say that definitively. That's just what it appears to be. Now, he was interviewed himself in 2017, and he said that he was on the trail. He parked at the Old Farm Bureau building, and he walked to New Freedom Bridge. And while at Freedom Bridge, he saw 3 females. He noted one was taller. He did not remember description, nor did he speak with them. They got his cell phone information. They got everything. The Farm Bureau building, they were like, it's the former CPS building. Like, they noted the type of vehicle that he had, all of that. Richard Allen was interviewed again October 13th, 2022. And actually, his being interviewed again does fall in line with the Keegan Kline stuff, but we'll go over that later this week. He said that he was on the trails. He saw the juvenile girls. He went on to the Monenhigh Bridge to watch the fish. And see, he's adding more things to what he did on the day 5 years ago, which is weird. This is not information that he had given them before. He said that he was wearing a black Carhartt jacket with a hood. He may have been wearing some type of head covering as well. He saw no one else but the juvenile girls. Richard's wife spoke and confirmed that he did have guns and knives at the residence, and also stated that Richard still owns a blue Carhartt jacket. They executed a search warrant on the 13th at his house. Among other items, they located jackets, boots, knives, firearms, including a Sig Sauer model P226 40 caliber pistol, and they gave the serial number, which I don't need to give y'all. Y'all can read. But between October 14th and October 19th, the Indiana State Police Laboratory performed an analysis on the Sig Sauer, and they did a physical examination and classification of the firearm, function test, barrel, and overall length measurement, test firing, ammunition component characterization, all of it. And after they had done that, they determined that the unspent round located within 2 feet of victim 2's body had been cycled through Richard Allen's Sig Sauer. They remarked, an identification opinion is reached when the evidence exhibits an agreement of class characteristics and a sufficient agreement of individual marks. Sufficient agreement is related to the significant duplication of random impressed marks as evidenced by the correspondence of a pattern or combination of patterns. So, based on the scientific research, based off of what they know, it matched. So they ran the firearm and found that Richard Allen had bought it back in 2001. Richard Allen voluntarily came to the ISP post on October 26th. He spoke to investigators, said that he never let anyone use his Sig Sauer, never did anything. This would be the judicial probable cause, because this is what he has been arrested and charged on. Although redacted, we will probably never see the unredacted document. But we'll get to that. I'll get to that. Don't worry. So, after everything from the gun to the unspent round to the jacket to the way that he is built to the pictures of people that have seen everything, it was believed that he was not seen on the trail after 2:13 p.m. because he was in the woods with victims 1 and 2. And based off of all of that information, they have the probable cause to believe that he murdered them. Okay. So that is what he is charged based off of. This is the document, at least what we will know of from the document. Now, once again, we didn't know any of this information until recently. However, this is just chronologically what was submitted to be able to get him, arrested with the charging documents. So, when this all came out, when they announced that he had a murder charge, they announced that on October 31st. They had not been releasing information due to the order to not have anything released. They didn't want anything to get out there to mess with the investigation because it is still technically ongoing. It is an ongoing investigation. So the next thing that we knew was November 2nd. I'm so sorry. I'm everywhere this morning. So on November 2nd, we got an order issued that was a public hearing notice on verified request to prohibit public access to a court record. Okay. So once this came out, once this was a thing that was put out to the public, that is when they put the information onto the chronological case summary saying what he was being charged with. Now, so Indiana Code IC 5-14-3-5.5 is sealing certain records by court hearing and notice. So this section applies to judicial public records. As used in this section, judicial public record does not include a record submitted to a court for the sole purpose of determining whether the record should be sealed. Before a court may seal a public record not declared confidential under Section 4A of this chapter, it must hold a hearing at a date and time established by the court. Notice of the hearing shall be posted at a place designated for posting notices in the courthouse. At the hearing, parties or members of the general public must be permitted to testify and submit written briefs. A decision to seal all or part of a public record must be based on findings of fact and conclusions of law, showing that the remedial benefits to be gained by effectuating the public policy of the state declared in Section 1 of this chapter are outweighed by proof by a preponderance of the evidence by the person seeking the sealing of the record that 1. A public interest will be secured by sealing the record. 2. Dissemination of the information contained in the record will create a serious and imminent danger to that public interest. 3. Any prejudicial effect created by dissemination of the information cannot be avoided by any reasonable method other than sealing the record. 4. There is a substantial probability that sealing the record will be effective in protecting the public interest against the perceived danger. And 5. It is reasonably necessary for the record to remain sealed for a period of time, and sealed records shall be unsealed at the earliest possible time after the circumstances necessitating the sealing of the records no longer exist. Whew, that was a mouthful. Okay, so Basically, the state of Indiana requested that these records be sealed. Okay, they put in the verified request to seal them pending public hearing. So until that public hearing is held, none of the records can be public. That means that it is up to the state of Indiana to prove beyond a reasonable doubt that there is good reason to have these records sealed, because it'll impede the investigation, because it'll cause undue harm to someone else, because of the dangers that may happen, things like that. Okay? Now, this public notice was put inside of the courthouse on the 2nd. Mind you, that is November 2nd. He was arrested October 28th. It's 4 days. 5 days. Like, not a whole lot can happen in 96 hours. But a lot happened in fucking 96 hours. Like, the true crime communities that think that they're doing something just absolutely lost their collective shit over this case and over the fact that records were not public. Okay? There were a lot of people on subreddits and stuff that were concerned that Richard Allen didn't have a lawyer listed for himself, but it did come out that Richard Allen had said that he was going to get his own lawyer, and that did not work out, as we will see on November 9th, but we'll get there. We'll get there. So they announced, and see, they wouldn't have any unsealed info because the state of Indiana filed the request and was granted the request before they ever filed the probable cause affidavit. So there was nothing to be public record at the time. They were smart. They knew what they were doing. This is a 5-year-old, very heavily publicized case. Like, they knew what they were doing by filing that request. They really did. But at the same time, I don't think they expected the amount of backlash that came with it, that certain corners of the true crime community couldn't help themselves over. So they put out notice. They let everyone know, hey, there's going to be a public hearing. We're having it November 22nd at 9 a.m. Like, they let things be known. They put it out there. Now, after they scheduled the public hearing, they did all of that fun stuff. They also went ahead and scheduled the pre-trial conference for January 13th, and they scheduled the jury trial that was supposed to take place from March 20th until March 24th of this year. Well, November 3rd, things kind of went a little crazy on November 3rd. So, see, everything was scheduled. Got all the nice stuff scheduled. Now, it was requested. Here, let me scroll down to the first one. It was requested on November 3rd that Richard Allen get transferred to a new place, that he was not safe inside of where he was being held. Now, the request even states that it has nothing to do with anything that Richard Allen did while he was being held. It had everything to do with everyone else. Okay, so the sheriff said the aforementioned defendant, Richard Matthew Allen, has been incarcerated since October 26th, initially at the Carroll County Jail, and then transferred to the White County Jail at my request as sheriff of Carroll County, Indiana. The defendant has been charged in a high-profile cause, creating potential safety and security concerns because of extensive coverage from an array of various media platforms, both mainstream and social, throughout the state, the United States, and the world, which is absolutely correct. This case has been covered by a number of people for a number of years. So, in that the defendant has been charged in said high profile cause, it is felt by the undersigned potential safety and security concerns exist involving not only the defendant, but also both jail facilities in Carroll and White counties within the state of Indiana. Because of the aforementioned reasons, as Sheriff of Carroll County, I cannot provide the services, attention, or supervision necessary to protect or meet the defendant's needs or to ensure, protect, and guarantee the safety or security of the defendant's staff or facilities. Now, Carroll County is not very big. Carroll County is not big at all. In fact, when it comes to the Indiana court divisions, their district is District 10, which includes 3 counties that are very small. It is a small place. And housing a high-profile defendant is not safe, especially when you have so many people trying to get information. So much so that the judge was emailing with his PR person and happened to CC a news organization and was like, I am drowning here. This is not cool. I cannot keep fielding requests for information that is not public. Hey, Alibis. So that got filed. It got approved. And I will say this, because we're going to read this whole thing. Look, was this court order unprofessional as fuck? Absolutely. This was a very unprofessional court order. However, I think that that judge of a small town in Indiana just happened to be at his wit's end, and he said what he needed to say. He said everything that he needed to say. Okay? So, on November 2nd, 2022, Toby H. Lesenby, Sheriff of Carroll County, filed a request by the Sheriff of Carroll County to transfer inmate from Carroll County Jail to the custody of the Indiana Department of Corrections for safekeeping. The court, being duly advised, finds that defendant is an inmate awaiting trial and is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. This finding is not predicated on any acts or alleged acts of defendant since arrest, rather a toxic and harmful insistence on, quote, public information, end quote, about defendant and this case. In general, this court has 30 days to rule on any motion that is filed by a party in any case. See Indiana Trial Rule 53.1a. And I do have that. We'll go over that in a second. Yet, concurrent to the actual case naturally occurring, this judicial officer keeps getting direct requests from non-parties for, quote, public information, end quote, claiming that this officer has 7 days or 1 day when hand-delivered to respond to the request or face litigation. While this officer is responsible for the entirety of the circuit court docket, it attempts to ignore the maelstrom of, quote, interest from the public. It is known that YouTube already hosts content regarding family members of this judicial officer, including photos. The public's bloodlust for information before it exists is extremely dangerous. All public servants administering this action do not feel safe and are not protected. The Carroll County Sheriff has limited resources to conduct its base operations, let alone any duties mandated by our Supreme Court. All defendants in all actions are presumed innocent. All public information will be available the second it exists. None of the family members of public servants are part of this action. All of the public servants are simply people doing their jobs. Most of the public servants are woefully underpaid. Most of the, quote, public interest consists of people attempting to raise their status or profit financially. When the public peddles misinformation with reckless abandon, we all are not safe. As far as the public's desire to learn about access to court records, that educational effort cannot be by this officer educating each individual ad hoc whenever they choose to seek, quote, public information. These inquiries are inherently disruptive to the operations of the court, as they are wholly outside the operations of the court. As a branch of the Supreme Court, any request for public information about this action should be directed to whomever is the public information coordinator for the courts in general. If there is not such a position, our state may need one. Defendant indicated at the initial hearing an intention to hire private counsel. Defendant is reminded that he must retain counsel within 20 days of the initial hearing because there are deadlines for filing motions and raising defenses, and if those deadlines are missed, the legal issues and defenses that could have been raised will be waived or given up. If defendant is unable to retain counsel of his choosing due to financial indigency, defendant is reminded that he is entitled to court-appointed counsel and defendant will be examined upon request. The court notes for the public that when defendant appeared for the initial hearing, he was clad in protective gear. That protection was not to protect defendant from the court. That protection was to protect defendant from the public. Until a finding of guilt or a judgment of conviction occurs in any case, judgment must be reserved and the presumption of innocence must be respected and preserved. Accordingly, pursuant to Indiana Code 353311-1, the court orders the Sheriff of Carroll County to transfer defendant to a facility of the Department of Correction designated by the Commissioner of the Department as suitable for the confinement of defendant and provided that space is available. So ordered this 3rd day of November 2022. Now, was that unprofessional? Abso-fucking-lutely. But did he need to say it? Yes, he fucking did. If there is not public information available, that is not a call for you as someone on the internet to go and post pictures of the judge's family because you're unhappy with the fact that you don't get information. There is a reason that you don't have the information, and it's because it is not public record. Going around the confines of the law because you think you deserve to have this information that no one else has yet is just fucking stupid. Jesus Christ. Now, he did mention in this Trial Rule 53.1a. So, Indiana has these lovely things called the Indiana Rules of Court, and there are various sections that you can look at and read and all of this fun stuff. In this case, he is talking about Indiana Rules of Court, Rules of Trial Procedure, Rule 53.1a, Failure to Rule on Motion, which reads, in the event a court fails for 30 days to set a motion for hearing or fails to rule on a motion within 30 days after it was heard or 30 days after it was filed, if no hearing is required upon application by an interested party, the submission of the cause may be withdrawn from the trial judge and transferred to the Supreme Court for the appointment of a special judge. He gets 30 days. In fact, the fact that it only took 4 days to schedule the special hearing on the fact that everything was closed record Amazing, because it's a small town, and this is a high-profile case. Y'all had to wait 4 days for the announcement of that thing. Just 4. Why do you need more than that? Why do you need less than that, rather? Like, Jesus. Ugh. Naturally, as soon as that was released, as soon as that was put out there, yeah, our good buddy judge there, he recused himself. He quit. Yeah. He quit. So we have that, of course. Here we go. It's the order of recusal. He allowed the transfer. He said what he said, and he dipped. So the judge of Carroll County Circuit Court has determined that the particular circumstances within the underlying case warrant recusal and dictate that a special judge be appointed in this case. The court hereby recuses itself. Pursuant to local rule, that's what the LR stands for, that is local rule. Pursuant to local rule 08-CR13-19C, the court has determined that no judicial officer within the county may preside over this case. The court now certifies this matter to the Indiana Supreme Court for appointment of a special judge in compliance with local rule 08-CR13-19B and C. Ordered this the 3rd day of November. Now, the local rule that they are referring to states that pursuant to Indiana Criminal Rule 2.2 and Criminal Rule 13C, this rule shall apply to the reassignment of the case and the selection of special judges in felony and misdemeanor cases where a change of judge is granted pursuant to Indiana Criminal Rule 12B or an order of disqualification or recusal is entered in the case. Now, a special judge shall be selected from Section A. If no judge qualifies under Section A, then a special judge shall be chosen from Section B on a rotating basis. If no judge qualifies, then a judge shall be chosen from Section C. They specifically mention Section B and C here. So Section B says to ensure the effective use of all judicial resources within this administrative district, the Carroll Circuit and Carroll Superior Court shall maintain lists of eligible judges, including judges, 1, regularly presiding over criminal cases within this administrative district, and 2, from contiguous counties who preside over criminal cases and shall assign a judge from said list on a rotating basis. And Section C, upon certification to the Supreme Court of Indiana of cases in which no judge is eligible to serve as special judge, or the particular circumstance of a case warrant selection of a special judge by the Indiana Supreme Court. In this case, they went Indiana Supreme Court. And absolutely, PPGate. Also, hi, Nova Ray. But yes, the public is to blame 1000% for any court pause in this situation, because there was no reason that that judge had to be pushed to the limit of recusing himself after completely just biting the head off the public. Don't get me wrong, it was fucking awesome to read. Like, that was fucking great. I have never seen such an entertaining, unprofessional letter in my life, but still, should not have been a thing. It was unnecessary, just wholly unnecessary. So, of course, after that was filed, it did get approved. The Honorable Benjamin Diner, on his own, just recused himself and certified the matter to the Supreme Court. And it was ordered that Francis Gull appointed special judge. Now, Frances Gull so far has been an absolutely wonderful judge. She has been as fair as possible. She has put up with a lot of bullshit too, but we'll get to that. We will get to that. Now, uh, because she was appointed as a special judge by the Indiana Supreme Court, it does say right there, pursuant to Indiana Criminal Procedure Rule 13E, an oath of office is not required. What that means is a judge assigned under the provision of Indiana Criminal Rule 13 shall accept jurisdiction unless disqualified under the Code of Judicial Conduct or excused from service by the Indiana Supreme Court. The reassignment of a case or assignment of a special judge shall be entered in the chronological case summary of the case. An oath or special order accepting jurisdiction is not required because, well, this is a special case. And in this case, yes, they did update the rules of the chronological case summary. As you can see, the special judge was assigned. There you go. Actually, legally, they could not have gotten Judge Springer or Judge Judy because neither Springer nor Judy are able to preside over criminal procedures. They can only do civil. It's a whole thing. I don't know how many people know that, but yeah, like they're civil court judges. They are not certified to be able to preside over criminal proceedings. Yeah, it's the whole thing. So, yes, I agree. Absolutely, boo. Honestly, though, Jerry Springer has had a very fucking interesting life, and I cannot wait to go over it. But for now, let's move forward. So, we have all of this stuff that has happened. Now, the next thing that did happen was November 9th. November 9th, Richard Allen wrote a letter to the court. He hand wrote a letter to the court, actually. See? There it is. He explains to the court that he cannot afford a lawyer. He can't. His wife lost her job. They do not have the funding to be able to do this. Like, she had to, like, his wife had to move for her own personal safety because, again, some corners of the true crime community can't leave well enough alone. Stop it. Anyway, so yes, he did send in his letter asking them to please help get him someone, any assistance. Thank you. So that was sent November 9th. And like that was definitely a big concern for a lot of people. Hey, why does he not have a lawyer? And that's why. It's because he said that he was going to get a lawyer. He did not realize just how fucked everything was going to become. And it got to a point that he had to ask for help. That's why. A lot of people tend to forget that in the court of law, you are innocent until proven guilty. In this case, he was arrested on a probable cause. There is no without a shadow of a doubt in this case. There are shadows of doubt. But it's such a high profile case that no one wants to remember this. I'm not saying he's innocent. I am not saying he's guilty. I am just telling you what we know based off of everything that has been filed in regards to this court case. These are just the facts. Please remember that. Just the facts. Now, our next thing that happened was November 14th and 15th. Because, he submitted the request for counsel and he was granted his request for counsel. He did get yes, she was a civil court prosecutor and a family court judge. I think at one point she did do criminal, but you have to redo your certifications and stuff to be able to preside over criminal courts every so often. Like, you have to redo those certifications and stuff. And I don't think she ever followed up on it. But yeah. Now, I know that Judge Jerry, he never wanted to do criminal proceedings. He just wanted to be a judge. Yeah, I know that Judge Judy did practice in Connecticut for a bit because that's where her show was based out of, and she had to have the right certifications and stuff. But I think she did move to the New York area. We'll have to look that up in a little bit. We'll look that up. I want to know now. Where did Judge Judy go? Okay, so the court, now, something that we need to all remember about the chronological case summary is that it is never the full record of everything that is happening behind the scenes in a court case. In this case, he asked for a public defender. Okay. Now, when you request a public defender from the court, you do have a court administrator that is doing research behind the scenes to determine whether or not you are eligible to get a public defender, whether you are poor enough to get a public defender. So obviously he was approved. He got a public defender. All right. Now, our next thing that happened. They put out the courthouse management and order of decorum because the public hearing scheduled for the 22nd. Okay. See, that's right there. Look at that. Isn't it nice? And it was telling people, hey, you can't record in here. You will get your shit taken away if you're caught recording. You can take notes. You can tweet out stuff. You can't bring in any weapons. It's just saying, hey, look, these are the rules of this hearing, right? So they put that out in preparation for the hearing on the 22nd. And all was gravy with that. Not too many complaints from the public until you get complaints from the public for other reasons. So a petition to let bail was filed on November 21st. Okay. Now, a petition to let bail. Let me scroll because there's a lot of notes here. I'm sorry. I'm very prepared. Yeah. A petition to let bail in this case, they're trying to get Richard Allen bail. They don't think that he should be held without bail because, that's stuff for him. It's their thing. It's their job. So here we are, the petition to let bail. Now, Article 1, it does mention right off the bat, Article 1, Section 17 of the Constitution of the State of Indiana. And that section of the Constitution of the State of Indiana does read, offenses other than murder or treason shall be bailable by sufficient sureties. Murder or treason shall not be bailable when the proof is evident or the presumption strong. Now, some will argue that with the probable cause affidavit that was filed and the fact that it was seen as having probable cause enough to arrest him for murder of two peoples, that the presumption is strong. So I don't know what they're getting at with that one, because the presumption is very clearly strong. You know what I mean? Now, they also mention Indiana Code 35-33-8-2, murder, other offenses. Murder is not bailable if the state provides by a preponderance of the evidence that the proof is evident or the presumption strong. In all other cases, offenses are bailable. Again, the presumption is very clearly strong. So that's a thing. The presumption is strong. You were literally arrested on a probable cause affidavit because the presumption was so strong. Yes. His charging documents do say murder. In fact, murder while trying to kidnap. So I'd say the presumption is pretty strong, especially when they did it to two people. Two children, mind you. It was a whole thing. Probably cause. Probably, did I? But yes. So they tried to put in a petition to allow for him to get bail. Now, they did schedule a hearing about that, but we'll get to that because that wasn't for a couple days. Okay? So they filed that petition at the same time that they filed that petition. This lovely group called the Media Interveners, which covers Indiana Broadcasters Association, Inc., Hoosier State Press Association, Inc., the Associated Press, Circle City Broadcasting, Wish TV, WRTV, WXIN/WTTV, Wolf Boom Radio, Tegna Incorporated, WTHR, the Indianapolis Star newspaper, American Broadcasting Companies, aka ABC News. They filed by their lawyer, who filed a brief for them. Now, see, if you remember, I said that for that public hearing on the whole redacted documents thing, on the whole gag order that there was in place, pretty much. Well, not gag order, but yeah. So I said, I clearly read from the actual law itself that you can file a brief. And that is exactly what these assholes did. They filed a brief. Media Interveners pre-hearing brief seeking public access to probable cause affidavit and charging information. Yes, they filed this. Before the hearing, the day before the hearing. They filed this. Now, the court did not acknowledge this until the day of the hearing, but we'll get to that. So. Oh, hi, Lex. Two Guns. Yes, Red Eye is a poopy head. So, the Media Interveners filed this brief. Now, a brief is a written argument submitted to the court. Lawyers often prepare briefs which highlight and clarify certain information or legal comparisons in an attempt to persuade the courtroom to rule in favor of that lawyer's client. Now, briefs are primarily prepared by lawyers working on any given case. High-profile Supreme Court or appellate court cases may inspire third parties to submit briefs, which is what this is. This is a third party. And this is an amicus, AMICUS brief, which are prepared by people with strong interests in the outcome of the decision and function of this. In this case, the media really fucking wanted information. They wanted to have access to information. And in order to get access to that information, they cited 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 pieces of case law. They cited 11 pieces of fucking case law to try and persuade people. 11. There's no reason for that. There's zero reason for all of that. Like, also, they keep quoting the Indiana Rules of Court, Rules on Access to Court Records, Rule number 6, excluding other court records from public access. Now, they seem to be skipping over Part A, which says, and I quote, "In extraordinary circumstances, a court record that otherwise would be publicly accessible may be excluded from public access by a court having jurisdiction over the record. A verified written request to prohibit public access to a court record may be made by any person affected by the release of the court record." Huh. Wild. Oh, and they have to, like, the court can say no. The court can absolutely say no. They can be like, nah, we can't allow this. So we're going to make everything public record. But they said yes pending public hearing, which is exactly what's fucking happening. Why are you quoting this law when they are following this law? You're quoting it like it's some gotcha, but it's not. They're literally doing what the law fucking says. Why are you stupid? I don't know. Is your lawyer qualified to write stuff like this? Because it sounds like they're not. And I'm just a layperson. I'm not a lawyer. I am seriously, like, not a lawyer at all. But all of this stuff is there. It is public access. You can find all of these laws and all of these rules. But yes, it's a thing. They filed this. They were very proud of themselves. You can tell. Look at how long this is. This is ridiculous. Look at that. Just all of this. Basically, they were just saying, hey, we are the gateway for the public to have access to all of this information. We are important because the Supreme Court has says that we are important. Let us do this. Yeah. Like, it just, look at, there was no point to this, you guys. But anyway. So that's a thing that happened. That's a thing that was filed. As you can see, here it is where the appearance was filed. Here's where they filed the brief. Now, they did have the hearing. Exactly. I am not a lawyer, but I do advise people about lawful law. Because you know what? It's easy to find the lawful law. It's all over the internet. The lawful law is there. So, now, on the 22nd, they did hold the hearing. Okay. Oh, yeah, I know. Oh, yeah. But, like, here's the thing, though. Like, this, they hired a lawyer to do that for them. This entire big, huge thing right here, the media interveners group has a lawyer that wrote this that is stupid. There's no reason to cite 11 pieces of case law when you just want to, like, yeah. Yeah. There was no reason for that. That was a waste of money on the media interveners' part. Let's put it that way. Oh, I almost hit the wrong button. But yes. Yeah, we're on November 21st. We're about to go into November 22nd. We started all the way back at October 28th. We have covered the probable cause affidavit, the charging information, what has gone on within the court leading up to this moment, including the recusal of the original judge of this case and the appointment of a special judge. So yeah, there's a lot. And I covered the legal laws, because legal laws, it's public information, the legal laws. So that all happened on the 21st. Now, the 22nd was the hearing. And at the same time that they had that hearing, our lovely, lovely state of Indiana filed a motion for order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication, aka they filed a gag order. Now, the gag order was not, done that day. We'll get to that. We will go over this in just a second. However, comma space. So, now, as you can see, the hearing, the public access hearing, was held on the 22nd. The gag order was filed on the 22nd. They canceled the pretrial conference that was originally scheduled for the 13th. They scheduled a hearing for the 17th of February. Now, this is just letting you know that a hearing was held on the state's verified request to prohibit public access to a court record. The matter is taken under advisement. The judge did not rule that day on whether or not information would be released and records would be public. They did not let that be known. They did schedule a hearing for the 17th of February in regards to the petition to let bail. Now, the omnibus was rescheduled to the 17th at 10 a.m. by the agreement of counsel. Now, an omnibus hearing, because I have all the information. Oh, hey, BGTV. Nice to see you. Now, an omnibus date per Indiana Code 35368-1, a date known as the omnibus date must be set by the judicial officer at the initial hearing and must be no earlier than 45 days and no later than 75 days after the completion of the initial hearing, unless the prosecuting attorney and the defendant agree to a different date. The purpose of the omnibus date is to establish a point in time from which various deadlines under this article are established. The court shall direct the clerk to notify the defendant and all counsel of record of the omnibus date. So, once you set that omnibus date, that gives you the deadline on when you have to submit your discovery, when you have to submit all of these different things that are needed for the actual hearing itself. Discovery can be a long process, which is why there is that 45 to 75 days for the opposing counsel to be able to get access to all of the discovery details. Know what I mean? It's the whole thing. Oh my God. No, they don't always succeed at everything. Jesus Christ. Okay. So, they listed the reason for the hearing on the 13th being canceled as judicial action. A judicial action is a judgment, decree, or decision rendered by a court which concerns a contested issue brought before the court by parties who voluntarily appear or who have been notified to appear by service of process. So basically, there was disagreement on something, so they had to cancel. That's it. That's what it means. There was a disagreement on the whole bail thing, so they canceled and they rescheduled. Gotta love it. Now, the gag order that was in place, or the gag order that was filed, was done because of the media. Once again, because of all of these people that think that they have a right to this information that, well, they don't. They filed this. The case has received extensive treatment in the local, national, and international news media. Media accounts concerning this cause have contained an undue number of statements relating not only to the progress of the investigation, but conclusions of the investigation, some of which have been untrue. It is reasonable to believe that the media will continue to cover this cause of action extensively and that the publicity will prejudice a fair trial. That the additional statements and media coverage in the news is likely to produce prejudice in the community, making it impossible to have a fair and impartial jury to ensure that all parties have a fair trial. The state filed this. The state understands that, hey, if we let this keep going, we're not going to be able to have a fair trial for this person. And that's not cool. Like, everyone is entitled to a fair trial. You have a right to a fair trial. So they're trying to ensure that Richard Allen gets his right to a fair trial by filing this. Now, it was taken into consideration. Nothing was done about it on the 22nd. Okay. The court did note the filing of the media interveners pre-hearing brief thing. They take it under advisement, of course. Oh, just wait. There's a reason that the gag order got approved pending public hearing or pending hearing. I'll get to that though. I'll get to it. It's not even like, it's not even the public's fault this time. It was his lawyers. It was Richard Allen's lawyers, but we'll get there. Terrible. Okay, so the day after they have this public hearing about whether or not they should make the whole thing public, like the probable cause affidavit and the charging information, the media interveners, in all of their stupidity, it's hard to tell at this point. I'd say stupidity, but that's just personal opinion. They filed this. Now, it is a motion of leave to intervene, and they filed this the day after the hearing. They waited one whole day. So, a motion for leave is a request for permission to file something that isn't allowed as like a matter of right under the law. So, like an extension of time to file something past the filing deadline, or if there's not a rule of procedure that covers something, then you file a motion for leave. In this case, the media interveners, well, they want to intervene with the course of law because reasons. Mind you, the judge has not ruled on anything yet. The judge is taking everything into consideration. Francis Gull is doing their due diligence to ensure that everything is done right by the law. They are a Supreme Court judge. They can do that. So, they filed this. They once again quoted the Indiana Rules of Court, Rules on Access to Court Records, Rule number 6. Why they keep, I don't know. They also once again quoted Indiana Code 5-14-3-5.5, sealing certain records by court hearing notice. They followed all the rules. They did what they were supposed to do. Like, they followed the rules. It's one of those things. Okay. They also quoted Indiana Code 5-14-3-4A, records and recordings exempted from disclosure, time limitations, destruction of records. Now, Section 8 of that code just lists out what is accepted from everything and may not be disclosed by a public agency unless access to the record is specifically requested by like state or federal statute, or is ordered by the court under the rules of discovery. I don't know why they quoted it. I really don't. Like, it did nothing to add to this document. You know what I mean? And when they filed this to leave to intervene, they also filed another document, a post-hearing brief. Why are you wasting some poor soul's resources to type all of this up for you? See? Now, they did, during the public hearing, the state said that the media was going to extraordinary lengths to get a soundbite, which, I mean, they're not wrong. In a way, they're not wrong. Is it the news's job to report on these things? Absolutely. But you can also report on what is public record, which in this case is everything that's in the chronological case summary. You can report on all of the stuff in the chronological case summary. You can report that he is being charged with murder. You can report that various motions were filed. You can report, hey, we cannot give you more information until information is available to us. What is the point? I understand that the media has a job. I understand that they have this obligation in a way to report on these things. However, comma space, you cannot go around the confines of the law to get your story. They're already like taking things into consideration. The judge is already doing what she can to make it to where something can be known. Y'all are just being dicks at this point. You know what I mean? Once again, I am not a lawyer, so like, but yeah. That's the thing that they filed. So, they're doing the most, as one does. Now, the judge did determine that because at the hearing, they did have a redacted version of the charging documents and a redacted version of the probable cause affidavit that they presented, and were like, well, we have this. It's something. So they considered, and the judge determined that the redacted version of the probable cause affidavit and the redacted version of the charging documents could be released, but the unredacted version could not without a court order. Okay, so that those charging documents that we saw at the very beginning, the probable cause affidavit that I briefly went over, that is the redacted version. We will very likely never see the unredacted version. I am not about to try and go get a court order for that. You know what I mean? Like, it's not a thing that's going to happen. So, the judge approved the redacted version. Now, here is the paperwork for that. Order or judgment of the court. The court, having had this matter under advisement following a hearing conducted on November 22nd, 2022, and having considered the evidence submitted and the arguments of counsel, now denies the state's verified request to prohibit public access to a court record in part. The court finds that the state has failed to prove by clear and convincing evidence that the affidavit of probable cause and the charging informations should be excluded from public access. The court finds that the public interest is not served by prohibiting access, and that the protection and safety of witnesses can be ensured by redacting their names from the affidavit, and that the defendant's personal information can be removed from the charging informations. The court notes that the prosecuting attorney submitted charging informations and a probable cause affidavit at the November 22nd, 2022 hearing that was redacted, eliminating the witnesses' names and identifying personal information of the defendant. Those documents will be released to the public and made part of the record of this cause. The original charging informations and affidavit of probable cause shall remain as sealed and confidential court records as they are not redacted. The court further finds that the media intervener's motion for leave to intervene is moot and therefore denied. Court orders that the redacted charging informations and affidavit for probable cause submitted by the state at the hearing conducted on November 22nd be filed with the clerk of the court with this order, and further that the clerk shall not release, without prior court approval, the original sealed, unredacted informations and affidavit. Dated November 28th, 2022. All they had to do was be patient. The judge was deciding on things. Like, the judge was doing the things that judges are supposed to do. Okay? There was no reason for any of that. Now, at the same time that the judge approved that to be released, there was a request filed for a change of venue for Richard Allen. It's right, yeah. Verified motion. Now, the verified motion for a change of venue does go on to explain that, they're allowed to make this request per Indiana Rules of Criminal Procedure, Rule 12A, which that reads, in criminal actions and proceedings to enforce a statute defining an infraction, a motion for change of venue from the county shall be verified or accompanied by an affidavit signed by the criminal defendant or the prosecuting attorney, setting forth facts in support of the constitutional or statutory basis or bases for the change. Any opposing party shall have the right to file counter affidavits within 10 days, and after a hearing on the motion, the ruling of the court may be reviewed only for abuse of discretion. Now, it is a good, it's actually a very good listing out of why the venue should be changed. Richard Allen's lawyers are absolutely right. The allegations stem from the highly publicized deaths of 2 Carroll County teenagers. Even before Richard Allen had been accused of these crimes, the matter had been highly publicized. The extensive media attention began while the victims were missing, all the way back on February 13th, 2017. The extensive media attention continued after the victims were found the very next day. They list out that this continued for the next 80 months, 5+ years, in a variety of formats. He even lists out like Google trends and searches for the area and explains why you cannot have an unbiased jury in this area. Like, it makes sense. So I'm honestly hope that they do approve the change of venue, because he is right. He's not going to get a fair trial if it is held in Carroll County. It's just not a thing that's going to happen. So, and anyone that disagrees with me, well, I'm sorry that you don't want to give him a right to a fair trial. Like, he deserves one. Like, it's constitutional. You know what I mean? Anyway, So, the redacted probable cause affidavit was released. That is the one that I went over with you. Now, on December 1st, the judge decided, okay, what we will do is we will have a hearing on the gag order request, and we will have a hearing for the change of venue on the same day. We will do it January 13th at 10 a.m. Not a problem. We will have that hearing. It was scheduled. All was well. Things were going good. And then Richard Allen's lawyers are kind of really dumb at times. See, they put out a press release themselves. His lawyers put out a press release. Now, we're going to go through this. I have time. We're going to go. Okay. As Rick Allen's attorneys, we have received multiple requests from local and national media for interviews and comments since the unsealing of the probable cause affidavit. It would be virtually impossible to comply with these requests and continue to focus on the merits of Rick's defense. Therefore, we offer up these thoughts. We do not want to try this case in the media, and we intend to adhere to the Indiana rules of professional conduct that provide guidance on pretrial publicity. However, the police and prosecutor's office have conducted many press conferences over the 5+ years of this investigation and following our client's arrest. On the other hand, Rick's ability to assert his innocence has been reduced to only one short post-hearing press conference. Accordingly, we feel it appropriate, necessary, and within the bounds of our rules of professional conduct to make a few comments concerning the probable cause affidavit and Rick's innocence. Oh boy, this is a fun document, you guys. Rick is a 50-year-old man who has never been arrested nor accused of any crime in his entire life. He is innocent and completely confused as to why he has been charged with these crimes. That is not true. That is very not true. The cops did actually go to his house multiple times on domestic violence related things. Just saying. That's a thing. Good job, Rick. Don't lie. The police did not contact Rick after Libby German and Abby Williams went missing. Rather, Rick contacted the police and voluntarily discussed being on the trail that day. Like many people in Delphi, Rick wanted to help any way he could. Rick contacted the police to let them know that he had walked on the trail that day, as he often did. Without Rick coming forward, the police probably would not have had any way of knowing that he was on the trail that day. Actually, that is not true, because you have the witnesses that saw him. But I digress. Rick volunteered to meet with a conservation officer outside of the local grocery store to offer up details of his trip to the trail on the day in question. Rick tried to assist with the investigation and told the police that he did recall seeing 3 younger girls on the trail that day. His contact with the girls was brief and of little significance. Rick does not recall if this interaction with the conservation officer was tape recorded, but believes that the conservation officer scribbled notes on a notepad as Rick spoke to him. After Rick shared his information with law enforcement officials, he went back to his job at the local CVS and didn't hear from the police for more than 5 years. The next time Rick heard from the police was in October 2022. This was approximately 2 weeks before a contested sheriff's election and within days of a federal lawsuit filed against the Carroll County Sheriff's Office by its former second-in-command, Michael Thomas. By the way, I do have that lawsuit. I will be going over it on another day, but it has nothing to do with this case presently. I digress. In the lawsuit, Thomas claims that Thomas, had made suggestions and offered assistance in the investigation of a high-profile child homicide investigation, but those suggestions and offers were rejected by the sheriff. Thomas further claimed that the sheriff and others in the department feared the disagreements with Thomas would become publicized as a result of the political campaign for sheriff. I don't know. We'll go over that. Yeah. Thomas claims in the suit that he was ultimately demoted and replaced by Tony Liggett, who later that year won the 2022 election for sheriff. Furthermore, Thomas claims he was also removed from high-profile cases. Now, if you're bringing a lawsuit forward, it's entirely possible that they caught wind that you're bringing a lawsuit forward, and so they remove you from high-profile cases because they're afraid that your lawsuit's going to, like, intervene with your job. It's a whole thing, but I digress. In the 5+ years since Rick volunteered to provide information to the police, Rick did not get rid of his vehicle or his guns and did not throw out his clothing. He did not alter his appearance. He did not relocate himself to another community. He did what any innocent man would do and continued with his normal routine. Whew. The probable cause affidavit seems to suggest that a single magic bullet is proof of Rick's guilt. It is a bit premature to engage in any detailed discussion regarding the veracity of this evidence until more discovery is received, but it is safe to say that the discipline of tool mark identification, ballistics, is anything but a science. The entire discipline has been under attack in courtrooms across the country as being unreliable and lacking any scientific validity. We anticipate a vigorous legal and factual challenge to any claims by the prosecution as to the reliability of its conclusions concerning the single magic bullet. There's more than just the magic bullet. There's a few things. I went over it in the probable cause. On Rick's behalf, we argued to have the PCA unsealed. Rick has nothing to hide. As importantly, we were hoping that we would receive tips that would assist us in proving up his innocence. Not surprisingly, we have been inundated with tips from a variety of sources, all of which will be vetted by our team. Although it is the burden of the prosecutor to prove Rick's guilt beyond a reasonable doubt, the defense team looks forward to conducting its own investigation concerning Rick's innocence. We appreciate those that have reached out to support his cause. The prosecutor mentioned at the last hearing his belief that others may have been involved in the killing, yet there was no mention in the PCA about a second suspect involved in the killing. The defense is confused by such discrepancies in the investigation and will be in a better position to respond as more discovery is received. Look, it's a probable cause affidavit for the arrest of one person. You're not going to mention the other people involved when you are looking at the probable cause of the singular person that you are currently trying to arrest. That is just the weakest argument. It's like the fucking Juan David Ortiz case all over again, where they kept arguing about his goddamn admission. Like, what? Stop it. Anyway, Rick Allen owned a Ford Focus in February of 2017. His Ford Focus is not in any way similar to the distinctive look of the PT Cruiser or smart car that was described by the witnesses. It seems that the CCSD is trying to bend facts to fit their narrative. Jesus Christ. At this point in time, we have received very limited information about this case and look forward to having something more to view than that which was offered up in the sparse PCA. Moving forward, it is our intent to scrutinize the discovery as it is received and give the necessary attention to the volumes of tips that we are receiving. To the extent we continue to discover information that points to Rick's innocence, we will offer up this information to the public so long as we are not prohibited from doing so as a result of the recent request by the prosecutor for a gag order or by the Indiana Rules of Professional Conduct. Brad Rossi, Andrew Baldwin, attorneys for Rick Allen. Jesus Christ. Okay, quick pause on this. Yes, Darrell Brooks did in fact get a fair trial. Darrell Brooks was offered up every opportunity to have his own defense. He had his own defense for a while. He had lawyers. His lawyers at any time could have requested a change of venue. However, Darrell Brooks kept fucking with everything so much that he was firing his legal counsel over and over and over, up until the point where he was like, I'm gonna do this myself. He could have filed for a change of venue. He could have done anything. He could have looked up the actual rules of criminal procedure and done an okay job, but he didn't. He chose to not file the change of venue. He chose to not file the things that he could have because he's incompetent. They allow you to go to the library and they allow you to look at all of the law books if you were defending yourself in court. They give you all of the tools that his defense lawyers, before he fired them, gave him a map of things to do, of how to handle everything. They gave him the road work. He chose to not follow it. He was given a fair trial. He's stupid, but he had a fair trial. Just saying. Now, Rick Allen's attorneys should not have done this. They should not have done this. They did this on December 1st. Now, the judge had already they had already scheduled a hearing for the gag order. They had not put a gag order in place. Whoa, wrong button. My bad. So, that was December 1st. Good job, you guys. Way to put that out there. Now, because of this, on December 2nd, we got this. On court's motion, in response to defendant's undated press release, the court issues an order granting the state's motion for order prohibiting the party's counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication in whole, pending hearing, which the court has just recently scheduled for January 13th, 2023 at 10 a.m. in the Carroll Circuit Court. Counsel for the state of Indiana and the defendant, as well as their professional staff and other personnel, law enforcement officials, court personnel, coroner, and all family members are prohibited from commenting on this case to the public and to the media directly or indirectly by themselves or through any intermediary in any form, including social media platforms. Counsel are reminded they are required to conform to the Indiana rules of court, rules of professional conduct, specifically Rule 3.6, trial publicity in its entirety, and Rule 3.8, special responsibilities of a prosecutor in its entirety. Violations of this order are punishable as contempt of court and subject the violator to a fine and or incarceration. Had his lawyers kept their mouth shut, this gag order would not have been put into place. They would have just waited and had a hearing on it on the 13th. No problem. But they had to go and say something. They had to do it in a way that would piss the judge off. Jesus Christ. Don't do that. Don't piss the judge off. That's the last thing you want to do is piss the judge off. Now, from there, from the gag order being filed and everything, our next big thing did not happen until December 8th. Now, December 8th, Rick Allen's lawyers did file an ex parte motion. Now, this motion for leave to proceed ex parte on defendant's motion for public funding for cost of representation, including expert fees and expenses. Now, this particular motion was actually really well done. This was a really well done motion. It was, in fact, approved by the court on December 12th. So, when he filed this, his counsel was very thorough. Okay. So, Ex parte, by the way, in civil procedure, it's used to refer to motions or orders that can be granted without waiting for a response from the other side. So, like, they can file all these motions, and the prosecution really can't do anything about it. It's just up to the court to be like, yes or no. So, yeah, let's go over this document because this was really well done. This was excellent, actually. So, they want to permit the defendant to file an ex parte motion for public funding for cost of representation, including expert fees and expenses under seal, conduct ex parte hearings upon that motion, and order the court reporter and all other court personnel to maintain all pleadings and hearings concerning the defendant's application for appointment of experts confidential and not discuss or disclose to any person, including the special prosecutor or any of his agents. In support of this motion, defendant asserts the following. Okay, so the defendant is charged with the crime of murder. We know this. Defendant is without funds and cannot afford the costs of representation, including expert fees and expenses, including transcripts and investigators necessary to assure him an adequate defense in a fair trial in this matter. The defendant is entitled to proceedings on his application for cost of representation, including expert fees and expenses under Aki versus Oklahoma and its progeny. Quote, Indiana's practice of providing indigent criminal defendants with the means to defend themselves long predates such requirements as exist under the federal constitution, Scott versus State. Carroll County's public defender is eligible for reimbursement if its comprehensive plan complies with the Indiana Public Defenders Commission's standards. Standard N is applicable to this request, and a copy of the full standards is attached. It, in part, recommends an ex parte application and hearing, which, yes, it does. I looked at it. You can actually find that piece of information online. It's actually copy, paste. There you go. That is the public defender indigent defense non-capital standards. Like that is the document right there. Ta-da. Now, continuing. A trial court may, upon a showing of good cause, permit an ex parte request for funds for assistance, as per Stevens v. State. Further, the Indiana Supreme Court amended Criminal Rule 24 effective January 1st, 2001 to specifically authorize ex parte hearings for funds applications in capital cases. There is no reason why ex parte hearings in non-capital cases should be considered improper, especially in a murder case. And that is actually a very fair point. If you are being charged with murder and you are, a capital defendant, you have the option to apply for all of these things to help you with your case. So why can't you do the same for someone that's just being charged with a regular felony murder? That makes sense to me. I don't know if it makes sense to y'all, but it's fair. It really is. The funding of representation, including expert fees and expenses, including transcript fees and investigator costs, in this case is necessary in order for a defendant to present an adequate defense and be afforded a fair trial, a showing which defendant is prepared to make in an ex parte hearing. Oh, yes, actually, as soon as it's over, it's going to stay up. I don't take my streams down. So, it'll be there for you. You can hear all the legal laws. To effectively show the need for assistance and enable this court to make informed decisions, defense counsel must reveal to the court their theory of defense, attorney-client confidences, work product material, and other privileged information. Denial of this motion would force defendant to make a public filing and have an adversarial hearing on their application for public funding of representation, investigative, expert, and other services necessary to present an adequate defense. Forcing defendant to make their request for funds in a public adversarial hearing would restrict their ability to make a detailed showing of need and would deprive this court of information necessary to make its decision regarding expenditure of public funds. An adversarial hearing would violate the provisions of Indiana Trial Rule 26b-4, which is based on the work product privilege and provides that counsel need not disclose the names and opinions of experts unless and until the defense decides that these experts will be called as witnesses at trial. Now, I do have those rules right in front of me. Okay, so work product privilege, by the way, it permits attorneys to withhold production documents and other tangible things prepared in anticipation of litigation by or for another party or its representative. So, as with like attorney-client privilege, work product privilege does not protect like underlying facts, just the things that they discover. All right. So, Rule 26B4, scope of discovery. Unless otherwise limited by order of the court in accordance with these rules, the scope of discovery is as follows. Discovery of facts known and opinions held by experts otherwise discoverable under the provisions of subdivision B1 of this rule and acquired or developed in anticipation of litigation or for trial may be obtained as follows. 1. A party may, through interrogatories, require any other party to identify each person whom the party expects to call as an expert witness at trial, to state the subject matter on which the expert is expected to testify, and to state the substance of the facts and opinions to which the expert is expected to testify, and a summary of the grounds for each opinion. Upon motion, the court may order further discovery by other means, subject to restrictions as to scope and such provisions pursuant to subdivision B4C of this rule concerning fees and expenses as the court may deem appropriate. B. A party may discover facts known or opinions held by an expert who has been retained or specially employed by another party in anticipation of litigation or preparation for trial, and who is not expected to be called as a witness at trial only as provided in Rule 35B, or upon showing of exceptional circumstances under which it is impracticable for the party seeking discovery to obtain facts or opinions on the same subject by other means. And C, unless manifest injustice would result. 1. The court shall require that the party seeking discovery pay the expert a reasonable fee for time spent in responding to discovery under subdivision B4A2 and B4B of this rule. And 2. With respect to discovery obtained under subdivision B4A2 of this rule, the court may require, with respect to discovery obtained under subdivision B4B of this rule, the court shall require the party seeking discovery to pay the other party a fair portion of the fees and expenses reasonably incurred by the latter party in obtaining facts and opinions from the expert. Woo! Yeah. So basically, people that have the money, that can afford all of these experts, all of these opinions, all of these things in discovery, it isn't fair to those that don't have the money to afford these things. You know? So, an individual with sufficient funds available for the costs of representation, including expert fees and expenses, would be able to retain counsel and pay for the expert fees and expenses, and would not be required to disclose the names of experts used for consultation and investigation unless and until it was determined these experts would be called as witness in trial. Now, okay, so granting a wealthy person the protection afforded by the work product privilege while denying an indigent person the same protection solely because of their indigency would violate the indigent person's equal protection as guaranteed by the 14th Amendment to the United States Constitution and Article 1, Section 23 of the Indiana Constitution. Now, Article 1, Section 23 of the Indiana State Constitution, because I have that as well, says, let me pull it up. That's the 14th Amendment. Hello. There we go. The General Assembly shall not grant to any citizen or class of citizens privileges or immunities which, upon the same terms, shall not equally belong to all citizens. Fair enough. Now, the 14th Amendment, it kind of falls into both the 5th and 14th Amendment because both contain a due process clause. Although the 14th Amendment applies explicitly to the states, the Supreme Court has interpreted that the due process clauses in both articles as having like the same meaning. So due process is generally understood to contain two concepts: procedural due process and substantive due process. Procedural due process refers to the constitutional requirement that when the federal government acts in such a way that denies a citizen of a life, liberty, or property interest, the person must be given notice, the opportunity to be heard, and a decision by a neutral decision maker. The clause also promises that before depriving a citizen of life, liberty, or property, the government must follow fair procedures. It's not always enough for the government just to like act in accordance with whatever law there may happen to be. Citizens may also be entitled to have the government observe or offer fair procedures, whether or not those procedures have been provided for in the law on the basis of which it's acting. Action denying the process that is, quote, due, end quote, would be unconstitutional. So Judge Henry Friendly had an article called Some Kind of Hearing, and he created a list of required procedures that due process does require. And while it's not mandatory, it remains highly influential, both in its content and its relative priority of each item. And those are an unbiased tribunal, notice of the proposed action and the grounds asserted for it, opportunity to present reasons why the proposed action should not be taken, the right to present evidence, including the right to call witnesses, the right to know opposing evidence, the right to cross-examine adverse witnesses, a decision based exclusively on the evidence presented, opportunity to be represented by counsel, requirement that the tribunal prepare a record of the evidence presented, and the requirement that the tribunal prepare written findings of fact and reasons for its decision. So yes, that very much is true. It would violate his equal protection under the 14th Amendment. So, in Beauchamp versus State, the Indiana Court of Appeals rejected an equal protection challenge to the denial of ex parte funds requests, finding a rational basis for requiring a specific showing of need for expert assistance. However, the Beauchamp court did not address the equal protection implications of requiring an indigent person to make the showing in an open court, revealing work product and other information to the state. Defendant does not object to the requirement of making a specific showing of need for expert transcript fees and investigation expenditures, but rather objects to any requirement they make this showing in open court, revealing work product and otherwise protected information to the state, which is entirely fair. If someone that is paying for private counsel does not have to reveal these things for funding, then someone that cannot afford private counsel should not be required to do the same. Defendant has no voice in the selection of expert witnesses employed by the state or in the selection of law enforcement officials who assist the prosecuting attorney in preparing the state's case against them. To allow the state to have a voice in preparation of the defense case would violate principles of fundamental fairness, which is also true. Like, really, his lawyers did a great job of writing this up. They did. This is the one smart thing they did. Good job. The denial of this motion would violate defendants' rights to fundamental fairness, to the effective assistance to counsel, to present evidence, to be free from compulsory self-incrimination, to confront witnesses, to compulsory process, and to equal protection of the laws as guaranteed by the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as by Article 1, Sections 12, 13, 14, 19, and 22 of the Indiana Constitution. I have already covered the 14th Amendment, however, comma space. When it comes to the 5th Amendment, quote, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The clauses incorporated within this amendment outline basic constitutional limits on police procedure. And like that entire thing was actually formed because of the Magna Carta, because it was an early example of a checks and balances safeguard, as it had established the Council of Barons as a predecessor to the Parliament, which monitored the king's actions to assure he abided by the new law and like rectified breaches of the law. So yeah, it was a whole thing. Magna Carta. Scholars consider the Fifth Amendment as capable of breaking down into the following 5 distinct constitutional rights: the right to indictment by the grand jury before any criminal charges for felonious crimes, a prohibition on double jeopardy, a right against forced self-incrimination, a guarantee that all criminal defendants have a fair trial, and a guarantee that the government cannot seize private property without making a due compensation at the market value of the property. So yeah, that's the Fifth Amendment. No, there is not. I'm allergic to pineapple, so I can't have it on pizza anyway. The Sixth Amendment guarantees the rights of criminal defendants, including the right to a public trial without unnecessary delay, the right to a lawyer, the right to an impartial jury, and the right to know who your accusers are and the nature of the charges and evidence against you. And the Eighth Amendment: excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The excessive bail section provides constitutional protection against excessive bail, including the practical denial of bail by fixing its amount unreasonably high. Excessive fines is constitutional protection against, grossly excessive fines. And cruel and unusual punishment provides constitutional protection against grossly disproportionate punishments for capital sentences. In the case of non-capital sentences, gross disproportionate requirements are only available in exceedingly rare and extreme cases. And it also provides constitutional protection against inhumane conditions of confinement, which, by the way, that means that every single Border Patrol holding cell is in violation of the Eighth Amendment, but we'll talk about that later. So, yeah. And the Constitution of the state of Indiana, pretty much all of the sections that he quoted agree with what I just told you about the Constitution of the United States of America. Yes. You are now a YouTube chat constitutional law expert. I cannot give you a degree in that. Ms. Parker can only give out degrees, but I'll talk to her. I'll see what I can do. She gives out degrees for legal laws. But yes. So, the ex parte motion for public funding for costs of representation, including expert fees and expenses, would be filed under seal and would not be served upon the prosecuting attorney. This motion would be sealed and preserved as part of the court's record, in this case for future appellate review, should such review be necessary. the hearing on defendant's ex parte motion for public funding for cost of representation, including expert fees and expenses, would be recorded by the court reporter, transcribed, and sealed for purposes of appellate review, should such be necessary. Now, this was filed December 8th. And as you can see, right, here, right here, on the 12th, it was granted. Like, that was a very well done motion. Like, they did cover all of their bases. They made sure that they were quoting the right laws. They did not do what the media interveners people did and quote everything, all of the things. So yes, it was well done. It was granted. They filed on the 21st for a motion authorizing funding for a fact investigator. That has not, hold on, let me double check. Yeah, no, that has not been granted yet. We'll get to that. Hold on. Anyway. Hello, new thing that happened today. Sorry, I'm excited. I love legal law. So on the 30th, a supplemental motion for discovery and request for Rule 404 and 405 evidence. That was filed on the 30th. That was the last thing that I had on here, but it's okay. We'll also go over today because apparently something happened and I am excited. Yay. Okay, so this is the Rule 404 and 405 evidence request. Now, I'm not going to read the entire thing to you like I did the other ones because this one is this one's pretty straightforward. They want to know the information that the prosecution has. They want to know all of the stuff that the prosecution has found thus far in discovery when it comes to the case against Richard Allen. Including like things from confidential informants, stuff like that. Now, Rule 404 is character evidence, crimes, or other acts. So they want evidence of the defendant's pertinent trait. And if the evidence is admitted, the prosecutor may offer evidence to rebut it. They want to know evidence of the alleged victim's trait of peacefulness to show that, you know, they weren't the first aggressor, which in this case, it was children. It was children. They want to know, like, any and all things in his criminal record, any and all things inside of witnesses' criminal records, things that would prove that the witnesses used were not credible or will not be credible. Rule 405 is methods of proving character by reputation or opinion. When evidence of a person's character or character trait is admissible, it may be proved by testimony about the person's reputation or by testimony in the form of an opinion. On cross-examination of the character witness, the court may allow an inquiry into relevant specific instances of the person's conduct. If in a criminal case, a defendant provides reasonable pretrial notice that the defendant intends to offer character evidence, the prosecution must provide the defendant with any relevant specific instances of conduct that the prosecution may use on cross-examination. By specific instances of conduct, when a person's character or character trait is an essential element of a charge, claim, or defense, the character or trait may also be proved by relevant specific instances of the person's conduct. So yeah, they want to know what type of character witnesses are you going to use for both myself and the other people? What witnesses are you going to use at all? And are they credible? Are there things that would make them not credible? That's what they want to know. Yeah. So now I'm super excited because something new happened today and we're about to go over it. So today, January 9th, court orders the supplemental motion for discovery and request for Rule 405 and 404 and 405 evidence set for hearing January 13th. Oh, yay! It's another thing added to the... Yes. Court further orders defendant's ex parte motion order authorizing funding for fact investigator set for ex parte hearing on the 13th at 11 a.m. Ooh, okay. So on the 13th, we are going to find out a bunch of things. First things first, we are going to find out if the gag order will remain in place. We're going to find out if the order to change venue will be granted. We are going to find out if the supplemental motion for discovery and request for Rule 404 and 405 evidence will be granted. And we will find out if the ex parte motion and order authorizing funding for fact investigator will be granted. We got a lot going on the 13th. I am excited. First hearing's at 10 a.m. The second is at 11 a.m. And I will be sure to let you guys know the updates on all of that. So, it has been 2 hours. I have covered this entire goddamn case summary, and I told you legal laws. I taught you about the U.S. Constitution. This has been interesting. So, as you know, there is a link pinned at the top in the comment section. That link will take you to the indigenous people's charities that we're having people donate to. What you do is you click a direct donation link, you make a donation, you take a screenshot of your receipt, you black out all of your personal information because we don't want to know. You send that blacked out receipt just showing the organization and the amount you gave to postaliguana@gmail.com. We will add it to the total. Right now, we are at $820 out of the $2,000 goal. And that $2,000 goal, we're hoping to reach by January 31st. If we reach the $2,000 goal, Security Monitor Lizard and I will be eating a Cobb's burger. If you make a single $150 donation to one of those organizations at one time, just like that one time $150 donation, then we have to eat a Code Red Mountain Dew hard-boiled egg. We fucked ourselves and did not give a limit on how many eggs we would have to eat, and we are currently at 4. We each have to eat 4. Son of a bitch. Anyway, if we reach the $2,500 mark, then the absolutely wonderful Slim Living Cyborg and Dungeon Queen will go egg for egg with us, and Slim will eat a burger as well. But that's only if we reach the 2,500 mark. We are just hoping to reach that $2,000 goal. We absolutely appreciate everyone that has already donated and everyone that is hopefully going to donate. I appreciate y'all listening to me go off about this because I have done so much research. Oh my God. Okay, so 13th hearing. Oh, that's your birthday? Yay! Okay, I'll be sure to wish you a happy birthday on that day. I won't forget, I promise, BBK. But I will update you guys after all of that happens on the 13th. And then next week, we will be talking about Ron Logan and Keegan Kline. Both of these are also moving pieces in this entire thing, but they are not currently relevant to the charges being brought forth to Richard Allen, so I did not include them in this stream. Thanks for being here. I love you guys, and I will catch you on the next one. Where's my cursor? I'm bad at this.